Judge Shapiro, it looks like we have attorneys for both parties, and I can bring them in whenever you're ready.
Hello. There we go.
Good morning, Your Honor.
Good morning, Your
Good
Honor.
morning. So we have Mr. Grill for the state and the individual defendants, right?
Yes, Your Honor.
All right, and Mr. Savage for the plaintiff.
Correct, Your Honor.
All right. All right, so
Judge
I'm going to
Shapiro,
call.
I
Yes.
just want to let you know that I'm having a little issues getting the court reporter moved over to the panelist thing, so it might be a minute or two.
Okay, we'll just wait. I'm going to mute and stop my video. When she comes on, we'll all be back. Okay.
Okay.
Oh, nope, here we go. She's coming. There we go.
All I had to do was stop video. Hello, Ms. Roberts.
Hello.
Are you ready, Ms. Roberts?
Was I take a picture of the screen so I know who's here?
Very good.
All right.
Ready?
Yes.
All right, I'm going to call these cases. There is the initial Court of Claims case, well, it's Genuine Solutions Counseling Center and Scott Hall versus Governor Whitmer et al. Case number 21-185MM. And we also have a companion case. And I'm embarrassed to say I don't have the case number in front of me. But it's the one that was recently, I think, transferred from the circuit court. And before we're done here, I'll get you the case number. Do either of you, gentlemen, have it handy so the court reporter can get it now?
Judge, that's okay. I took a picture of the screen before you all came on. I had it.
I didn't hear. But
Oh, I
All
see
right.
it. I said I took a picture of the screen before you all came on. It had both captions on it. You don't need to
oh,
get it.
very good. All righty. Tell you what, let's have both attorneys put their appearances on the record, and then we'll turn to Mr. Grill, who has the motion.
Great. Thank you, Your Honor. Attorney William Savage on behalf of the plaintiffs, P82146.
Your Honor, Assistant Attorney General Eric Grill on behalf of all of the defendants.
All right, very good. So, Mr. Grill, this is your motion, and you may proceed.
Thank you, Your Honor. I know the court has read the briefs. I won't read everything over again. It's a pretty straightforward matter. I initially filed these motions as an effort to kind of simplify the case, which I guess in retrospect is kind of, it no longer really seems to fit the description. But in short, Your Honor, this particular motion in the original Court of Claims case was brought on the basis of the notice provisions of the Court of Claims Act, requiring that the plaintiffs file their action within 1 year of the claims accruing. Even taking plaintiffs' latest possible calculation of when they think their claims accrued, the claim should have been filed by August 25th, 2021. Plaintiff did not file anything until September 26th of 2021. And as
So you in 1 year, you meant 6 months, I think.
It's 6 months, Your Honor, but I think like the latest possible, it's 6 months personal injury damages, it goes back and forth, but by any calculation, the last possible date that this case should have been filed was August 25th of 2021. The plaintiff didn't file until over a month later, so which makes the claims untimely. I will acknowledge that after we had a status conference in this case, something the court said to me kind of stuck, and I went back and re-examined the cases. And I subsequently realized that the notice requirements have been held not to apply to individual defendants, which is something, honestly, I was not aware of. It's a relatively recent case, and I apologize to the court. So the argument still holds true for the state of Michigan, the departments, and all of the official capacity claims. So those still are subject to the notice requirements, and those should.
Why does it apply to official capacity claims if the reason it doesn't apply to individuals is that the language is not in the statute, and here it says state and its agencies. It doesn't include officers, just as it doesn't include employees.
The reason being, Your Honor, would be that when you're making a claim against an officer in their official capacity, it's basically a claim against the state. Then in that respect, they're not there as an individual, they're being basically as an avatar of the state. And so there's no distinction between the Department of Health and Human Services or the Department of Attorney General and the individual in their official capacity.
And why is it different than for an employee, which is in Pike was held, it doesn't apply to employees?
And again, Your Honor, I think in that specific circumstance, because the employee, I think, was still being named as an individual for their liability in whatever capacity they had. And I'll confess, I don't have a lot of details on what the capacity in Pike was. But in this case, we're dealing specifically with both. We've got individual claims, we've got official capacity claims, and it certainly seems to me that there's no basis for an official capacity when we have the individual. So in federal courts, this is widely recognized that we're talking about official capacities. It's the same thing as the state of Michigan, and I think the rationale applies equally well here.
So, and I'm going to ask Mr. Savage as well, for practical purposes, what difference does it make? In other words, if I were to assume that the individuals are in.
I'm sorry, Judge, I didn't hear you. What difference does it make? And what did you say after that? Yes, Judge. Right after you said, for practical purposes, what difference does it make?
Yes, if the individuals are in, how does it matter whether we say individual capacity or official capacity?
Well, Your Honor, it matters in one respect to the fact that the state of Michigan is, it gets to be sued on the terms it decides. And so if we accept the premise that official capacity is the same thing as the state, then the state has only waived its immunity and allowed suits to proceed under certain circumstances that have to be met. One of those is the notice requirement. And that hasn't been met in this case. And so the claim against the officers in their official capacity.
Something's wrong with the audio today. You all are going in and out, and I'm not hearing every word.
Okay, I'll start again. When we're, I apologize. What was your question again? I've lost my train of thought.
My question?
Yes.
I think you pretty much answered it. I certainly understand the legal position, and I realize that's what controls. I was just trying to understand if there was also a practical difference in terms of anything, how the case would go forward, but that's okay.
I think from a practical standpoint, it's a shorter motion I'm going to have to write once this all gets resolved regarding the individual defendants, and I don't have to address, again, the official capacity claims later on. But I think also, frankly, they are straight up resolved as a matter of law on the regard that it's the state of Michigan.
All right. Let me just see if I have any other questions. And what is your response to the argument that under Mays, that there is an exception to the 600-6431 standard?
Your Honor, I simply don't believe that's correct, and I don't think that there's any basis for it. What would be the basis for that exception? If you can refresh my memory, Your Honor, it's been a minute. I looked at this. What is and maybe I can address this better on rebuttal to the claim, but as far as the exception there, the multiple courts repeatedly, and especially from McCahan on down, have said that these notice requirements are explicit, they have to be strictly observed, and that there's not a lot of wiggle room here. The only exception to that was the Ely Company case, which dealt specifically with whether or not you could relate back a verified complaint to a claim that was otherwise timely filed. And even then, the state of Michigan has argued and is still arguing that that you don't get to do that. But at least the Court of Appeals in the Ely Company case said we're going to allow that. So there's a narrow foothold there to say that if you file timely in the circuit court, the case was removed to the Court of Claims, and it's an unverified complaint, you could amend the complaint to make it verified, and they're going to let that go forward. That's a very narrow exception that simply has no practical application here, because the earliest filing in this case was already late. So there's nothing to relate back to.
Anything else you want to say before we go to Mr. Savage, or you'll have rebuttal? So
Nothing I can think of on this, Your Honor. I know there's another motion that I think we'll probably deal with in sequence.
With,
There's the other motion in the other case. I figured, I'm assuming that we're going to do this one at a time, and then we'll deal with that one next.
well, I confess, is there, maybe I didn't see that motion. Is the motion in the circuit court, the removed case, different?
It's slightly different, Your Honor, because when for the circuit court case that was removed, our argument there is that under C6, it's a duplicative complaint. They're identical. There is no difference in the parties. There's no difference in the allegations. And so under the court rule, it's a duplicate, and only one of these cases should go forward. There's some other elements in there that concern whether or not the Court of Claims has jurisdiction over individual defendants that we've addressed separately in that brief. For the reasons that we've stated there, obviously, it is our position that the Court of Claims has jurisdiction over individual defendants, specifically officers, employees, and even volunteers of the state of Michigan are part of the state, the commission of the state, when we're talking about the Court of Claims.
Thank you. All right, Mr. Savage.
Yes, thank you, Your Honor. Yeah, so taking things in order, well, I guess the first thing I should address is this 6-month statute of limitations. When it was originally put in the original motion, I kind of thought it was just, defense counsel being thorough and listing the entire statute, which says 1 year, or if it's a personal injury, 6 months. So I didn't really address the 6 months there. But then in their reply, they came back and said, no, we're talking about the 6 months and the 6 months only, because this is a personal injury case. I don't know if anybody else here has done a lot of, automotive cases or anything, but I mean, personal injury to me is defined as actual, like physical injury. And so I took the liberty of looking it up in Black's Law Dictionary, personal injury. And the definition there is in a negligence action, any harm caused to a person such as a broken bone, a cut, or a bruise, bodily injury, also termed bodily injury. And that's the 11th edition of Black's Law Dictionary, 2019. I think that, there's a claim for malicious prosecution. There's a claim for gross negligence. There's a claim for intentional infliction of emotional distress. None of those fall within the personal injury definition. And so none of those fall within the 6 month limitations period. So I really do believe we're dealing with the 1 year statute of limitations period. That said,
I also have Black's here.
Oh, okay, great.
The second definition is any invasion of a personal right, including mental suffering and false imprisonment. That seems certainly broader than a broken bone.
Yeah, I guess in the second definition, I would think I would think the first controls, but the second definition, mental anguish. I mean, this was perhaps for the IIED claim only that could apply, but certainly not to the other two, where this was a case of malicious prosecution and the gross negligence claim. Of course, if somebody is grossly negligent against you and costs you, hundreds of thousands of dollars, it doesn't really matter how broken up you are about that. I think that in itself is an injury that is not a so-called personal injury. And the same applies to the malicious prosecution case. I don't believe there's certainly no requirement there that you have a certain amount of mental anguish and suffering. It's wrongful prosecution is wrongful prosecution. So really, I believe it's the 1 year statute of limitations is the only one that can be applicable here. And that began to run on February 25th, 2021, when the elements of malicious prosecution were met. And when it became clear to plaintiffs, or could have become clear, that something was really grossly negligent and that he was so mistreated here. Again, we're dealing with human beings and not just robots here. So in coming to the realization that you've been grossly wronged, the dismissal nolo prosecuti of the prosecution against you is a big part of that. And that did not occur until February 25th, 2021 as well.
You've got me on the accrual date, but I'm not so sure on the 6 months versus 1 year.
Well, I mean, in any time I've heard of personal injury, it's been referencing actual physical injury. If we adopt, defendant's definition, which I don't believe he put a lot of, he defined it in his briefs, but if we just adopt defendant's definition, it's anything. It's you cost me money, you hurt me financially. It's a personal injury because it was an individual contract with me. I mean, I don't think that can be the case. I think that personal injury here, at least in the statute, certainly has to use its plain meaning, which to plaintiffs is definitely a physical injury. In torts, that's how it's traditionally used, and in the law of Michigan, that's what I believe personal injury to be. I
think I also would like you to address the official capacity versus individual capacity.
All right, Judge, can you say that again?
I would like you to address the individual capacity versus official capacity, and how it applies to the Pike decision.
Yeah, so I think it's clear that the individual capacity defendants are in that sense, and the individual capacity defendants are also being sued in their official capacities. So they are in, I believe the statutory language is clear, although defense counsel states that these official capacity individuals are the state, and therefore, the law to bar suit against them applies. We have to go by what the statutes say and how they're interpreted. And I believe in Pike and other cases, they're interpreted as, no, these are individuals, and they're not listed under the statutes as being immune here, as being immune from suit here. So
and I guess, Mr. Grimm, what practical difference does it make? Are you concerned the state might not indemnify these individuals if you don't sue them in official capacity? Or is there, I just want to see if I'm missing something about why both are
I feel that it should, I feel that it will hopefully make no practical difference, in the sense that I would hope the state would indemnify them, but that is my fear, that the state will not indemnify them. And I believe that is the defendant's position, that there is a practical difference, that the state, I won't put words in defendant's mouth, I'm sorry. But that is certainly plaintiff's concern, that they will not be indemnified, that it will be for judgments against, personal assets, which is just, bankruptcy, that sort of thing. And so in that sense, it has the potential to make a very real practical difference. I know I put it in my brief. I did want to touch on the harsh, unreasonably harsh consequences doctrine, because I feel that's very applicable here, where everything comes together to put the statute of limitations, to basically bar plaintiff's claims if defendant's statute of limitations arguments are adopted. I think the statutes come together to act in a way that certainly wasn't intended to completely rob the plaintiff of their substantive rights here. to sue for malicious prosecution and to sue for the claims that follow out of that malicious prosecution. And I really want to emphasize the point that they do follow out of that. If you don't have the malicious prosecution, which could only have accrued on, when the case was dismissed on February 25th, 2021, you don't have the other claims. The defense counsel saying, well, you could have filed your notice beforehand, even if you didn't have the malicious prosecution case, you could still say, hey, you've been grossly negligent and you've caused me a lot of distress here. Well, people don't sue. Criminals who are charged with something don't automatically sue within 6 months or put a notice out within 6 months that, by the way, state, you're causing me a lot of emotional distress and I feel you're being grossly negligent here in prosecuting me. That's something that happens after, well, at least a great example is after a dismissal nolo prosecuti because the prosecutor's own expert witness comes out in your favor and says what you did was legal. I really do want to emphasize that the other two claims are born out of the malicious prosecution claim. So they are all one package, so to speak. That brings me to another point. It wasn't just plaintiffs that are alleging that what they did when they were prosecuted was actually lawful conduct. That was the prosecutor's expert that came and said that. This is over a year of prosecution before they consulted their expert who said, no, it was fine. It was lawful, anyways, I think, I don't know if, we're getting into it here today, but defense counsel did mention his initial goal was to try to simplify things. And I'd just like to put that on the record as well, that my initial goal was for simplification. The reason the claims were brought in the court of claims was, of course, so that claims could be brought against the state. But because there is a Sixth Amendment right to a jury trial here in all of these claims, I'm sorry. Oh, okay. I'm sorry. I thought I heard somebody. Because there is a Sixth Amendment constitutional right to a jury trial here, and because the statutes are specific that they are not to be construed to, remove somebody's right to jury trial. The idea was to consolidate the cases into the circuit court where a jury trial could be had for the claims, where it's applicable, and then against the state, no jury, which the circuit court could do. And so that is still what plaintiff is motioning for and asking for and hoping for.
So you have to remind me, I apologize, Mr. Savage, how did this second case end up here in the Court of Claims?
Well, that's the funny thing. There was a statute which defense counsel, I guess, realized existed where they could just simply remove it without a motion. They filed a notice of removal, and then the clerk in the circuit court simply sent it over to the Court of Claims. So it was not heard on the merits in that sense. In the circuit court, that motion actually was pending at the time that the defense counsel filed the notice kind of statutorily removing it. Of course, I've raised my objections to that. I don't feel that was properly done.
Well, let me stop you there. You say, I confess there may be a pleading here that I have not seen. When you say I raised an objection, you mean in the Court of Claims?
Yes, in the Court of Claims, in the second case, I raised an objection there in a brief.
Rule
Yes. I'm sorry?
Did I rule on that?
No, I don't believe anybody has ruled on that yet. No.
Okay. And, okay, I think I understand your argument. Anything else you want to touch on before we go to rebuttal?
Uh,
Fine if you don't. I think you laid it out.
I know that's always a tough question, but yes, Your Honor, I will cede the floor here. I guess. Well, I guess my last statement is I believe Pike controls, and I'll cede the floor.
All right, Mr. Grill. Before you start, can you give me the case number of the circuit court case that was transferred here, and does it have a court of claims number now?
It does, Your Honor. I believe that is Court of Claims number 22-000016 I don't have the circuit court case.
22. Huh.
There was a notice of hearing for the motions in that case this morning as well.
I apologize about that. Yeah, I mean, I will certainly review everything, and I'll issue a ruling on whatever's been raised, or whatever is before us. So go ahead.
I'm sorry, I don't mean to interrupt. I do have the Court of Claims case number if you wanted that, Your Honor. Okay, it's 21-1902225-CZ.
The circuit court case. That's the circuit court's number.
Oh, okay, got it.
Yes.
Okay, go ahead, Mr. Gill.
All right, just a few points, Your Honor. First, the notice that needs to be filed doesn't have to be a fully realized complaint.
Mr. You're going out. Something's wrong with your audio because I don't have a problem with anybody else's. Can you start that over, please?
Sure. The notice requirement for the state of Michigan doesn't require a fully actualized complaint or a list of particular claims. It only needs to say, I have a claim against the state of Michigan for this thing that occurred on this date. At the time Mr. Hall was indicted, he certainly would have been able to realize or had an idea that in his mind that he thought that his charges were invalid for some reason. And I think it's worth pointing out, it's not particularly factually germane here, but Mr. Hall waived his preliminary exam. And so there was certainly an operative understanding at the time and for some period during his prosecution that there was some legitimacy to the claims. Ultimately, for reasons that we will deal with in the future, the complaint with the charges were dismissed, which is what leads us here today. But the point is that Mr. Hall could have filed a notice of claim with the Court of Claims much earlier. In fact, he could have done it almost immediately after the indictment or after his licenses were revoked to at least give the state of Michigan the required notice. Be that as it may, I think the fact that plaintiff's argument that all of his claims basically flow in toward from the malicious prosecution highlights the risk of his argument that it would effectively lead to the negation of the notice requirement for the state of Michigan for all of his claims, because it all kind of flows from that. And that's kind of what the statute seeks to avoid. Notably, the statute is not limited to just personal injuries. The statute specifically, and I'm referring here to 6431, specifically includes claims for property damage or personal injuries. So not simply, it's not a piggyback of personal injury as defined in automotive law. As the court pointed out, personal injury is broader than that. And even if it wasn't, we also have property damage here as well. Regarding the difference between individual capacity and official capacity, I think the real question there, Your Honor, you said earlier about what the practical difference is and having a second to think about it. I think the practical implications here is who pays. If it's an individual capacity claim, as the court pointed out, there's at least the opportunity or the prospect that the state might choose not to indemnify. If it's an official capacity claim, I don't think there's really any distinction there. It's an official capacity claim is a claim and a judgment against the state of Michigan who would be subject to that judgment, which I think is all the difference in the world here. I want to emphasize that when we're talking about this notice requirement, it's not simply a statute of limitations. It's a component part of the ability to sue the state of Michigan. So it's not the harsh consequences doctrine here, I don't think is a good fit. We're dealing with with statutory provisions that the courts have repeatedly held must be strictly construed. And then lastly, just touching on one of the arguments Mr. Savage made about a Sixth Amendment right to a jury trial, there is no such right here. As we pointed out, and I guess this is a brief the court hasn't seen yet, but in our briefing on the motion for summary in the transferred case, we addressed the argument that the idea of a jury trial isn't whether a jury hears claims for malicious prosecution or injury to property. That's not the idea. The idea is, do you have a jury right to claims against the state of Michigan? And there is no such right, either under the US Constitution and the Sixth Amendment or under the state constitution, Michigan's constitution, and especially under the Court of Claims Act. So,
but they would as the individual, is that if
sorry.
In their individual capacity, you would agree that there's a trial right?
If the claims against the individual capacity is because they are part of the definition of the state of Michigan in the Court of Claims Act, that's the idea, is that when the legislature amended the Court of Claims Act to include those individuals as part of the state of Michigan, then that means that's not a right to a jury trial that existed. They are now part of the state of Michigan. It's not whether the jury has a right to hear claims of malicious prosecution. It's about whether the plaintiff has a right to a jury trial against the state, as defined now in the Court of Claims Act, as including its officers, employees, and volunteers. And that was a specific determination because the state of Michigan was getting sued a lot for actions of its employees, its volunteers, and its officials. And that was a determination by the legislature that wanted those claims heard by the Court of Claims.
Very good. I have one other question. Assuming we should be able to get a decision to you in writing, I think within 21 days, in the event that this case remains pending at that point, do we have a scheduling order in these cases?
Not yet, Your Honor. The motion for summary here was the first pleading out of the gate, so we haven't filed an answer yet. And based on where we are, since it looks like the individual claims against the individual capacity officers belong in the Court of Claims and we'll be stuck hearing those, the next motion would be a motion for summary based on C7, the fact that these officers are entitled to immunities. And so that would be the next thing that I think that's the next step we would have to take. So we may be a minute before we need a scheduling order on that, other than unless
well, let me tell you, I don't hold scheduling orders up for repeated summary disposition motions. You're entitled to file it, summary disposition motions, but my presumption is not that the case is not supposed to move while those are pending. So,
well, I guess the trick there, Your Honor, is we haven't filed an answer yet. So
not too late.
It's not too late, but we do get we are allowed to file those motions before we do. So,
but don't you get one pre-answer summary disposition?
The court rule doesn't say, and again, Your Honor, it was my intention that there would be only one. I apologize for that. That was it. We're here to some because of an error in my part that I thought the notice captured all of the claims. If I had known, I would have included the C7 as part of this motion. But the fact remains that immunity is immunity in the state of Michigan, and these officers are entitled to have that determination because it's not just immunity from liability, it's immunity from suit.
Well, I don't know what the law says, particularly about how many SD motions you can file before an answer, but I think it would be prudent on your part to avoid any question about it later, to file an answer if this motion is denied. That's your call. I haven't looked at any of the cases, but if I were on the other side from you, I would say something about it. So if you want,
again, it is certainly my intention to proceed this case with all dispatch, Your Honor. I'm not looking to prolong this. Honestly, very briefly after the court's order, I would imagine, we will have something else in front of the court.
Okay, thank you both very much. Is there anything that we've missed before we close?
Well, I don't know if your honor allows a very brief rebuttal. I don't want to drag it. Okay.
I'm not going to hear anything on the issue. Okay.
Very well. Thank you.
Gentlemen. And I think Ms. Roberts needs to know whether either of you are ordering this transcript, but the motion is concluded. Thank you very much.
Thank you, Your Honor.